As part of our weekly Death Row series, tonight we're covering the case of Willie B. Smith. Willie has spent close to 30 years on death row in Alabama after being convicted of kidnapping, robbing, and killing a woman named Sharma Johnson, the sister of a prominent Birmingham police detective. Willie, who has an IQ score of around 70, suffers from an intellectual disability, according to his attorneys. So his execution would be unconstitutional, according to a 2002 Supreme Court ruling. But its execution date is still set for October 21st. Joining me to discuss Willie's case and why that Supreme Court ruling might not matter is veteran death penalty attorney Kelley Henry. Great seeing you again, Kelley.
Thank you. Good to be with you.
All right, so Willie Smith, who has spent close to half his life on death row, fill us in on the facts of his case, would you please?
So Mr. Smith was convicted in Alabama and sentenced to death, but on the basis of a jury verdict that was split 10-2. That in and of itself makes this case an outlier, because in most jurisdictions, in order to be sentenced to the death penalty, to be given the death penalty, the jury must be unanimous. But Alabama is an outlier and allows a jury a judge to sentence a defendant to death based on simply a majority vote by the jurors in the case. What we know about Mr. Smith is that his IQ is in the range of individuals who are intellectually disabled. However, Alabama failed to recognize the standards of the American Associations for Intellectual and Developmental Disabilities as to what the definition of intellectual disability is. And so he received a score of 72 on one test. We know that these tests have a standard error of measurement of 5 points. So even though he scored 72, the Alabama law said he had to have a score of 70, a reported score of 70. This is sort of like how many angels can dance on the head of a pin, right? The 11th Circuit recognized in Willie's case that the court at the time it considered the intellectual disability issue was wrong, but because of procedural reasons, he could not obtain relief. And what they said was it was simply a matter of timing. And so because of this matter of timing, Mr. Smith now faces execution. So
I was going to ask you, since you've spent well over 2 decades fighting death penalty cases, what stood out about this case? Would it just be about Alabama being an outlier and them not recognizing the standards for identifying intellectual disability? What more could you say about this case that really does stand out from your other caseloads?
Well, Willie Smith's case is just emblematic of the problem with the criminal legal system, where we are having individuals who are African American and individuals who are intellectually disabled. There was a recent study by the Death Penalty Information Center, a nonpartisan think tank, that analyzed individuals who are on death row who have been convicted and sentenced to death who had an intellectual disability, and they realized that there's a staggering correlation between being African American and intellectually disabled and wrongfully getting the death sentence. They found that 80% of individuals who had been sentenced to death with an intellectual disability were also African American. Now, to those of us who are practitioners, it's not surprising. Individuals who are African American are already vulnerable to wrongful conviction and wrongful sentencing in our criminal legal system. But then you add on to that intellectual disability, and you see it's a staggering correlation between intellectual disability, race, and a conviction and sentence of death. And that, for me, in Mr. Smith's case, is, again, astonishing. And then you see that at least 2 jurors, even at the time of his sentencing, before they knew all of this information, would have sentenced Mr. Smith to life.
Kelley, Alabama has challenged claims that Smith is intellectually disabled by pointing to the fact that he held a full-time job prior to his arrest. What is your response to that argument?
That is an age-old stereotype that experts in the field of intellectual disability have debunked for years. And frankly, it's ableism. Individuals with an intellectual disability are capable of doing many things in the community with support. They can hold full-time jobs that include endeavors and things that are not particularly, that don't require higher level of functioning and cognitive abilities. That doesn't diminish their value in society. The fact of the matter is there are millions of Americans with intellectual disabilities who hold jobs and contribute to the community, are married, have families. They can do all of these things. And for the government to stereotype and belittle, quite frankly, individuals with intellectual disability is offensive to that community.
Well, as of right now, Smith's execution date is set for October 21st. However, his case is being heard by the U.S. Circuit Court of Appeals. What does that mean for his case moving forward?
Well, certainly the court can step in at any time and stop the execution. There are important issues in Mr. Smith's case, particularly regarding the issue of choice of execution method in his case. Alabama, in the wake of all of the issues with respect to lethal injection, adopted a separate method of execution. But because Mr. Smith, due to his intellectual disability, was unable to exercise a choice within the very short period of time he was offered, he could not take advantage of choosing a different method of execution. Lawyers on his behalf have raised a claim under the Americans for Disabilities Act saying that the state failed to provide him with enough time and with necessary resources in order to exercise his rights. The court could step in and stop his execution, and should, in my opinion.
And Kelley, here on Making the Case, we tell these stories, we cover these cases about people on death row, those who have intellectual disabilities. You've been on to talk about those. And it bears repeating that we are the only developed country that still continues to carry out death sentences. Is it fair to say that there's more importance put on finality than fairness?
Without question. Absolutely. The idea that we can and will carry out an execution for an individual who we know under the Constitution it is illegal to execute and still do so is abhorrent in a first world country. And yet we have seen that happen just in the past year. The federal government carried out 2 executions for Alfred Bourgeois and Corey Johnson. We recently saw the execution of Ernest Johnson in Missouri, and now potentially that of Mr. Smith in Alabama.
All right, veteran death penalty lawyer Kelley Henry, thank you again for weighing in and for your expertise. Appreciate you.